foreign company or employer must bear in mind that the relationship and balance between employer and employee in France is different from the one that generally encountered in the common law system and most of European laws. Also, the legal framework and the general day-to-day approach are also very different in France. It is pivotal to take in account that employment in France is not at will. There are numerous and complex rules to comply with. The legal relationship between employer and employee in France is very formal and heavily regulated. The most important difference is probably that the majority of direct and indirect legislation is held by most lawyers to lean in favor of the absolute protection of the interest of employee rather than the employer's interest. The distinction between executive employee and non-executive employee is also quite important in France. Broadly speaking, an executive employee would correspond to a category of employees with responsibilities and duties at an executive level within a corporation, and the French word non-executive employee would correspond to the remaining category of workers who came beneath this label. To pile up on an over 2,000 pages huge labor code, there is hundreds of branch agreements, conventions collectives, to take care of according to the industry where the employment agreement apply. Subject to a limited number of exceptions, the vesting of stock options to employees is not as widespread as within a number of common law jurisdictions, European jurisdictions, and subject to complex tax schemes. The Social Security French agency called URSSAF is a French quasi-state body which is responsible for collecting the multiple employee and employer contribution for health cover, unemployment insurance, retirement and pension plan. The burden falls upon the employer to declare and remit the relevant sums each month to the state agency. In general terms, the public policy provisions of French employment law, which are at the advantage of the employee as opposed to the employers, would be applicable in respect of all contracts of employment if working in France. Thus, agreement in whatever language drafted between parties, neither of which were French and made subject to an applicable law other than the laws of France, might nevertheless be likely to a construction wherein French public policy rules would prevail. It is possible for an employee to work directly in France as employee of an entity based outside of France. Nevertheless, social security, health, retirement, and other such contribution by the employer would usually be payable in France to the relevant state authority and agency, and an employee resident in France would normally be required to make a statement of his income to the French tax authorities.